I'm very pleased to be here today, and I wish to thank the organizers who have been named by Baroness Hale for inviting me. I must say that I was initially puzzled by the title of the conference, Engaging with International Law. As you all know, the English language is a very rich language, and the phrase engaging with international law can have several meanings. I trust that the organizers did not use the phrase in the sense of attacking or starting to fight an enemy and to wrestle it to the ground. But, of course, in the sense of dealing with or getting involved with, I hope, with something, in this case, international law. Despite this clarification, the title of the conference raises a number of questions and interrogations. Should we engage with international law? Why should we engage with international law? Is there any interest in doing so? Who should engage with international law? How should we engage with international law? What does engaging with international law mean anyway? I cannot, of course, answer all these questions in the brief time allotted to me. I'll try to address some of them, and in particular, why should we engage with international law? Who should engage with international law? And finally, how should we actually engage with international law? I will try to address them in turn. Let me first of all go to why engage with international law. And I will try to give you, to answer this question, a very personal answer. And to recall, in that context, the scene in season 1 of the Game of Thrones, which many of you may have seen, when Ned Stark tells his daughter Arya, "You were born in the long summer. You have never known anything else." Well, I was born after the Second World War. I am contemporaneous with the UN Charter, the establishment of the International Court of Justice, the decolonization of peoples previously under foreign domination, including my own country and many other African states, and the adoption in 1948 of the Universal Declaration of Human Rights, which coincided with the year of my birth. I was lucky not to have been born when peoples were being enslaved, when African peoples were being enslaved and placed outside the legal order. When African empires, kingdoms, and states were declared not to be subjects of international law, but terra nullius, to be conquered and occupied at will, and denied the protection of international law. When war was considered as a legitimate tool for the settlement of disputes among states, and when millions of human beings were put in gas chambers in Europe, and the law had nothing to say in defense of their humanity. For me, and I'm quite sure for many others who were born in the last 70 years, be it in Africa, Asia, Europe, the Americas, respect for the international rule of law, respect for the principle of equal rights and self-determination of peoples, the prohibition of the use of force among states by the UN Charter, the outlawing of genocide, and the protection of human rights has meant freedom, prosperity, and peace among nations, but also for many staying simply alive. I think that's more than enough reason to engage with international law. This was indeed a very long summer, much longer than the summer of the Game of Thrones. Our task is to ensure that it will not be followed by a long winter. It's my view that the best way to do it is through a renewed engagement with international law. It's only through a rules-based multilateral system that we can avoid a long winter for humanity, which has already experienced many painful winters in the past. Secondly, and here I turn to the law itself, it should be recalled that in 1945, the states that emerged from the Second World War made a fundamental choice through the United Nations Charter. They chose the rule of law to govern international relations. This choice did not come into existence overnight. It was a result of the evolution of human civilization. It came out of the realization that the old system, which had made war permissible to right wrongs, was not only barbaric and brutal, but fundamentally unjust. Might is right has never helped humanity to live together in peace or in harmony. President Eisenhower put it very succinctly in his State of the Union address of January 1959, when he declared that it was the intention of the United States government, and I quote, to intensify efforts to the end that the rule of law replace the obsolete rule of force in the affairs of nations, unquote. The obsolete rule of force had to be set aside for the sake of humanity. The embodiment of the rule of law in the United Nations Charter went hand in hand with a significant increase in the rules applicable to the relations between states. That increase was due to the conclusion of international agreements in a wide range of fields, from aviation to telecommunications, from labor standards to trade and investment, from human rights to humanitarian law, and all the way to environmental law and the protection of biological diversity. It also gave rise to thousands of treaties establishing cooperation among states, both at the bilateral and multilateral level. The old system of billiard ball coexistence of states, which consisted in simple juxtaposition of sovereignties, was replaced by a web of rules protecting common interests and shared values that have given rise to the idea of a community-based law of cooperation. This shift was rendered possible by a robust commitment of states immediately after the Second World War to the establishment of a rule of law at the international level, based on the principles of the UN Charter. It must, however, be acknowledged that the task remains incomplete. We have not yet achieved a full shift from a society to a community of nations, despite the reference in many multilateral instruments to the common concern of humanity. We see major initiatives launched by international organizations to address this common concern, amputated, curtailed, or outrightly rejected when they collide with individual state interests, sometimes interests of the moment, of powerful stakeholders. To the extent that each member of the international community is prone to pursuing its own interests, and state relations are predicated on self-serving reciprocal exchanges and short-term bilateral deals, rather than actions undertaken in the interests of the whole, the expression of common concern will just remain an expression. I have in mind here the kind of collective action required to deal with issues such as the protection of the oceans, the preservation of biological diversity, and the fight against global warming. These are issues that cannot be solved by the actions of one state, however powerful it might be. They must be tackled as community problems. They require community-based solutions. The third reason why we should engage with international law is that humanity had often experienced in the past the nefarious effects of the use of power unbridled by law. With the growing web of multilateral treaties among nations, which I described above, many of them undergirded by customary norms, with the establishment of the International Court of Justice and other adjudicatory bodies for the settlement of disputes, international law has become a real legal system characterized by a high degree of predictability and stability, in which, as observed by two British well-known authors, Robert Jennings and Arthur Watts, every international situation is capable of being determined as a matter of law. For the first time in human history, we have all come to recognize and rely, even in our everyday lives, on a rules-based international system which is universal in scope and around which cooperation among all nations can be organized and implemented. This is so despite the fact that there is no central legislator, nor a legislative body, strictly speaking, but a decentralized normative production of rules, the sources of which are set out in Article 38, paragraph 1 of the ICJ statute. However, without the continuous engagement of states to update the system and to ensure that it does not fall out of touch with reality, there is a risk that certain rules may become outmoded or inadequate for the purpose. Consequently, it is only through such engagement that the evolution of the law with the changing historical, social, and political circumstances can be assured. This was the case immediately after the two world wars. It was also the case in the aftermath of decolonization in the 1950s and 1960s. To conclude on this point, it bears repetition to state that international law today is a system from which we all benefit on a daily basis, but which is not often visible to most of us, except when some part of it is broken or is breached by the actions of a state or a group of individuals or corporations, particularly when such actions are amplified through the media. Neither everyday compliance with international law and its application by states, international organizations, and adjudicatory bodies, nor the benefits derived from it by individuals on a daily basis are publicized or regularly covered by the media. So who should engage with international law? Of course, we all know that states are the primary subjects of international law. We have also international organizations. But my answer would be that those who enjoy rights under international law should engage with international law, whatever may be their subjectivity under international law. Those who have obligations under this legal order should engage with international law. Those whose legal situation are regulated by international law should engage with international law, as well as those whose conduct can interfere with the full implementation of international legal rules. They should all engage with international law. So as you see, the list can actually be very broad and wide-ranging. Let me start with states, because of course it could be superfluous to say that states should engage with international law. They are the primary subjects, as I say. But we have recently observed the rise of sovereigntist political doctrines, which actually believe that international law is not good, perhaps, for the sovereignty of their states. So it is very important to underline that there is no contradiction between state sovereignty and international law. The obligations assumed by states through international agreements are not incompatible with their sovereignty. As was observed by the court in the Wimbledon case, the conclusion of any treaty by which a state undertakes to perform or refrain from performing a particular act is itself an attribute of state sovereignty. In any case, the sovereignty of states is a sovereignty under and not above the international rule of law. All states have to conduct themselves in their relations with other states within a legal framework, which is, of course, international law. To use the words of Judge Anzilotti, and I quote, "Independence is really no more than the normal condition of states according to international law. It may also be described as sovereignty, suprema potestas, or external sovereignty, by which is meant that the state has over it no other authority than that of international law." International organizations are also portrayed nowadays as potential threats to national sovereignty. This is certainly a mistake. When the court acknowledged in the advisory opinion on reparations of injury suffered at the service of the United Nations that international organizations enjoyed international legal personality, it took the time to clarify that this statement is not the same as saying that an international organization is a state, nor is it a superstate, whatever that expression may mean. In reality, the scope of engagement and the powers of international organizations are dependent on their member states. International organizations are governed by the principle of specialty. That's to say, they are invested by states which create them with limited powers in their area of competence. If I may take as an example the Universal Postal Union, and you may have read about it recently in the press, it is one of the oldest international organizations created already towards the end of the 19th century. It was established by the Berne Postal Convention of 1874, concluded among 22 nations at the time. According to the UPU, the convention succeeded in unifying a confusing international maze of postal services and regulations into a single postal territory for the reciprocal exchange of letters. The barriers and frontiers that had impeded the free flow and growth of international trade had finally been pulled down. According to the UPU, far from being a threat to national sovereignty, of course, such an organization offers a helping hand to sovereignty and to a fruitful cooperation among nations. It was in that spirit that an agreement was reached on 26 September 2019, which will apparently enable the United States to remain as a member of the Universal Postal Union and to continue to benefit from its services. It is also in that spirit that intergovernmental organizations have contributed and continue to contribute to the development of international law. They are not only the guardians of internationally agreed standards in their area of specialty, but states have delegated certain standard-setting powers to them so that they can further advance and update the rules applicable to their activities. Thus, unless their actions are undermined by the assertion of individual interests of states, particularly the most powerful ones, the engagement of these multilateral institutions with international law to foster their objectives and their consequent contribution to its development is part and parcel of their mission and of their raison d'etre. Turning now to human rights and the position of the individual in international law, it's worth recalling that international law rules, even if they were primarily conceived for the relations among states, are ultimately concerned with the individual human being, the ultimate addressee of all legal rules. Thanks to the large number of treaties concluded both at the regional and international level, the question of the protection of human rights does no longer fall under the domain reservé of states. If I take the example of African states, there was a period immediately after independence when the violation of human rights was exclusively viewed through the prism of colonial domination, foreign aggression, or apartheid in South Africa, while the acts of homegrown dictatorial and oppressive regimes were overlooked by African intergovernmental organizations, such as the Organization of African Unity, the predecessor of the African Union. However, following the entry into force of the African Charter on Human and People's Rights in 1986, the African Commission on Human and People's Rights was able to make the following powerful statement, in my view, in the context of a case concerning the people of Darfur in Sudan. I quote the statement of the Commission. There is a school of thought which believes that the right of a people in Africa can be asserted only vis-à-vis external aggression, oppression, or colonization. The Commission holds a different view, that the African Charter was enacted by African states to protect human and people's rights against both external and internal abuse, end of quote. The development of international law in this area of human rights over the last century has not only consisted in conferring rights to individuals, rights have also come with responsibility and obligations, especially international criminal responsibility. One may recall the famous statement of the Nuremberg Tribunal, according to which crimes against the international law are committed by men, not only by abstract entities, and only by punishing individuals who commit such crimes can the provisions of international law be enforced. Based on this principle of international criminal responsibility, international law has witnessed first ad hoc criminal tribunals, such as the Nuremberg and Tokyo tribunals, and more recently, the International Criminal Tribunal for ex-Yugoslavia and the International Criminal Tribunal for Rwanda, before the adoption in 1998 of the Rome Statute establishing the International Criminal Court. At the same time, the number of international crimes has expanded, adding to the classical prohibitions of piracy and slavery, crimes such as crimes against humanity, the crime of genocide, war crimes, and the crime of aggression. Now you may ask, how about other non-state actors? How about corporations? How about insurgents, rebels? How about civil society and non-governmental organizations? I don't think that we have the time to cover all of this, but let me say a few words about corporations. I think that the case of corporations is an area where there is a mismatch between rights and obligations under international law. Over the last century, international law has increasingly granted rights to corporations, ranging from certain rights similar to human rights to a variety of rights under bilateral and multilateral investment treaties. This has not been followed, however, by a clarification of their obligations, and even less the establishment of remedies in case of violations of international law. It might be time to take a closer look at this, at least for two reasons. One is climate change. It is impossible to fight successfully global warming without the involvement of major corporations, particularly those active in fossil fuel production linked to greenhouse gas emissions. The second is the current inability of international law to grapple with the impact of rapid technological advances on human rights and freedoms. Today, individual freedoms, individuality, and privacy are at risk of being affected or even manipulated by technological tools and social media platforms. Human rights and freedoms are not at risk here because of the state, but because of private entities. In Europe, there are rigorous new privacy rights now, thanks to the general data protection regulations adopted by the European Union. But how about the rest of the world? How do we protect personal data from being commoditized and traded every day without informed consent? How can we protect individuals against the dark side of technology? In my view, it can only be done through the rule of law, domestic and international. Legal defenses need to be built against abusive behavior arising from the use of such technological tools. Finally, I turn to how to engage with international law. I don't think that there is a better illustration of this than the recent debate in the House of Commons of the United Kingdom. It was fascinating for me to watch on television a debate on the Vienna Convention on the law of treaties and the clausula rebus sic stantibus in the House of Commons. That is how to engage with international law. International law as a horizontal system of cooperation depends on the reliability of commitments undertaken by states. So first and foremost, obligations have to be complied with. Secondly, pacta sunt servanda and good faith are essential to the integrity of the law. In its comments on the final draft of the Vienna Convention on the Law of Treaties, the United States observed that the pacta sunt servanda rule was the keystone that supports the towering arc of confidence among states. This basic rule of general international law requires that treaties are performed in good faith. However, confidence and good faith must be shown not only in the interpretation and application of treaties, but also in their negotiation and conclusion. It does not help confidence in the system if a state negotiates in earnest with all others, but afterwards either refuses to sign the resulting agreement or withdraws from it immediately after its signature. As the court pointed out in the nuclear tests case, trust and confidence remain indispensable in international relations, in particular in this age when cooperation in many fields is becoming increasingly essential. Today, we see a disquieting return to unilateralism in world affairs. Unilateralism is the complete antithesis of a culture of multilateralism and to a meaningful engagement with international law. This is even more so when unilateralism is invoked to justify the adoption of coercive measures or to forcefully request other states to change their conduct. Bilateralism is certainly better than full-blown unilateralism. Nonetheless, it still remains a very primitive manner of engaging with international law. Regulating global issues through a web of bilateral agreements has been tried in the past. It failed. At best, bilateralism leads to a fragmented legal order composed of contradictory international legal obligations. The difficulties experienced by the Tokyo Codes to regulate international trade through bilateral agreements should serve as a lesson in this regard. Predictability, stability, and certainty of the rule of law cannot be promoted through a web of bilateral treaties. A second manner for states to engage with international law is through a firm commitment to binding international dispute settlement. International tribunals and courts are the pillars of the rule of law edifice at the international level. It is, of course, not possible to have a rule of law without courts. International courts and tribunals have acquired a proven track record of their ability to settle disputes and to contribute to the development of the law. It is a great honor for the United Kingdom to be the only permanent member of the UN Security Council that has consistently maintained and continues to maintain its acceptance of the compulsory jurisdiction of the International Court of Justice under Article 36, paragraph 2 of the statute. Of course, it would have been much better if the declaration of acceptance was not riddled with so many reservations. Yet, this declaration testifies to the UK government's commitment to the international rule of law, of which it has been historically one of the tireless architects. Commitment to the judicial settlement of international disputes needs to be reaffirmed and strengthened. I am delighted to report that the confidence of states in the work of the court has been steadily increasing in the last decade. Today, we have 16 cases pending before the court from all parts of the world. That means 32 states out of 194. These cases involve nations from all parts of the world: 5 European countries, 6 African countries, 9 Latin and North American countries, and 6 Asian countries. The last case to be submitted to the court concerned the dispute between Guatemala and Belize, concerning Guatemala's territorial, insular, and maritime claims. What's unique about this case is that the two governments decided to consult their respective populations through referendums on whether or not their 200-year-old territorial and maritime dispute should be submitted to the International Court of Justice for settlement. The peoples of both countries have overwhelmingly expressed their confidence in the court and approved in those referendums the submission of the case to the court, which occurred in May this year. Allow me now to say a few words on non-state actors, including private individuals, and how they should engage with international law. The manner in which a non-state actor engages with international law will largely depend on its sphere of action. Drawing inspiration from categories that have been developed in the field of human rights law, I would say that all of us should individually or collectively promote, uphold, and respect international law to the extent of our sphere of action. The majority of the situations where non-state actors can engage with international law is through upholding and promoting international law. Upholding international law makes sense when legal obligations are not formally applicable to a given entity, natural or legal person, but that they are somehow relevant to its conduct. It means that such entities should align their conduct with the substantive and procedural guarantees contained in multilateral treaties, and even if formally they are not bound by such treaties. This idea was well captured in the UK Civil Service Act of 1996, when it provided that, and I quote, "Civil servants should serve their administration in accordance with the principles set out in this code and recognizing the duty to comply with the law, including international law and treaty obligations, and to uphold the administration of justice," end of quote. I am aware that this provision is no longer part of the law. It has been withdrawn in 2015 from the Ministerial Code of Conduct as well as from the Civil Service Code of Conduct. And domestic litigation to have it reinstated was not successful. I am, however, convinced that this does not mean that the UK civil servants and ministers are not required to uphold international law. Those who organized this conference did it, I believe, with a view to upholding international law. History teaches that how humanity engages with international law depends on the nature and scale of the challenges that it faces. When faced with the cruelty and inhumanity of slavery in the 19th century, states adopted in 1890 and 1926 binding legal instruments to prohibit and to cooperate for its suppression. When faced with the death of 75 million civilians during World War II, states adopted the Fourth Geneva Convention in 1949 devoted to the protection of civilians in times of international armed conflict. When faced with the uprising and opposition and rebellion of peoples all over the world against colonialism, states adopted and established the right of peoples to self-determination, which enabled colonial peoples to accede to independence and to facilitate the process of decolonization. When non-international armed conflict became the leading type of conflict, states adopted additional Protocol 2, which extends to these types of conflicts the elementary considerations of humanity. We need to act in the same way today against climate change and against the erosion of biodiversity. These growing challenges facing today's international community are well known. We need to act to adopt rules, multilateral rules, to counter them. There is no other way, in my view, to tackle them except through multilateral cooperation and by adopting multilateral rules, not unilateral actions. It is through such multilateral rules that we can at least address in part challenges of this kind, be they climate change, extreme poverty, global terrorism, and the erosion of biodiversity. In this regard, we need also more education and training in the area of international law, and particularly humanitarian law and human rights law. If we observe today the conflicts around the world, we see that there is more violations of humanitarian law and human rights law than in the past. As stated in the UNESCO Constitution, since wars begin in the minds of men, it is in the minds of men that the defenses of peace must be constructed. It is in the minds of men and women that the defense of peace through international law must be erected. Today, enough resources are not devoted to such education. Imagine if only those who sell weapons could include in each package a manual on the laws of war, or train the acquiring party in humanitarian and human rights law. I am quite confident that it would make lots of difference, short, of course, of stopping those sales, which would be a better option. To conclude, Let me say that engaging with international law does not mean necessarily promoting the status quo. Similarly to many other human endeavors, international law is perfectible, and some of the criticisms against the international law might even be well-founded. The rules-based international system may need improvement in certain of its aspects, and perhaps it needs to see its coverage expanded in order to address efficiently some of the common concerns of humanity. A legal system cannot be better than the social consciousness that it reflects. However, international law is an essential part of the progress of humanity. We owe much to its development for the long summer in the last 70 years. International law gives us a lexicon accepted by states and other actors in the international system. It offers us, for the first time in human history, a stable and predictable system of settling disputes between states without having to have recourse to violence and brutality. It is a framework through which rational people can find innovative ways to tackle our common challenges. It can help us avoid the coming winter if we all commit to engage with it. The United Kingdom, as a nation founded on laws, has been in the past and continues to be today at the heart of developing an appropriate infrastructure for the international rule of law. And one can hope, and I hope, that it will continue to do so even after the 31st of October 2019, whatever happens on that fateful day. I thank you.